Hello friends, welcome to Mentors Academy. Thank you so much for visiting our YouTube channel. Today we will be discussing UPSC, EVO and APFC exam previous year questions. Today's topic is industrial relations. Whatever UPSC has asked in past, we'll discuss topic wise. Today's topic is industrial relations. Okay, first question they have asked in 2016 in APFC exam, Assistant Provident Fund Commissioner exam. What they have asked: Industrial Disputes Act 1947 was enacted with which one of the following main objectives? You should know what is the objective aim of this particular act. Okay, to provide for the payment, first option they have given, to provide for the payment of wages to the employees of the industrial establishment. Second option is to provide for the registration of trade unions, and third option is to make provision for investigation and settlement of industrial disputes. Okay, fourth option is to provide for the health and safety of the workers. Please attempt, we'll discuss. Pause and attempt. Okay, the major reason behind bringing this act, Industrial Disputes Act 1947, when we got independence, okay, right, 1947 act is to make provision for investigation and settlement of industrial disputes. Whatever the industrial disputes are happening or going to happen, this act will try to settle those. Okay, right. Next question, you can see the explanation. The Industrial Disputes Act is the foundational law for managing and resolving conflicts between employers, whoever are providing employment, and employees, whoever are working in the company or industry. Its primary purpose is to set up a legal framework. Okay, it is an act, right? Statutory act. Legal framework for the investigation and settlement of industrial disputes. Okay, Industrial Disputes Act 1947 is very important for upcoming UPSC, EPFO, APFC and AO exam. Okay, which is going to be held on November 30. Okay, next question. Which one of the following is not included in the, not, you have to observe this. They are asking which is included, not they are asking which is not included. Okay, right. So in the fundamental principles set forth in the, see, there is a declaration, ILO declaration named fundamental principles. Okay, Declaration of Fundamental Principles and Rights at Work 1998. Okay, they are expecting whatever the principles established under these fundamental principles, core principles, whether these four are in these four, whether the other one which is not included is there or not, you have to find out. Okay, first one is freedom of association and the right to collective bargaining. First option, whether it is correct or not. Elimination of all forms, we have to identify which is not the core principle in fundamental principles. Okay, right. Forms of forced or compulsory labor. Third one, effective abolition of child labor. Okay, fourth one, right to social security for all. Please pause and attempt, we'll discuss. Please try to attempt whether you know or don't know. If you are attempting here, it will be useful for you in while attempting real exam. Okay, if it goes wrong, you will be able to find out, acha, why I did it wrong, like that. Okay, brain will keep those things very easily. Okay, right, whichever you got wrong. Okay, first option is this. Second, and see, simple, there are four core principles, four fundamental and core principles set forth in the, there is an ILO declaration on fundamental principles and rights at work 1998. He can ask the question, an ILO declaration on fundamental principles and rights at work is happened in which year? He can ask, he can give options. 1998, he or she can ask. 1998, 99, 2000, like this he can ask. 1998, please remember. Okay, right. First one is obviously correct. Freedom of association and the right to collective bargaining is there, and elimination of all forms of forced or compulsory labor is also there. Okay, effective abolition of child labor is also there. Fourth one is not there, though ILO mainly focuses on social security. Its main goal is social security, right, in International Labor Organization. But the fundamental rights declaration, fundamental principles declaration of ILO happened on 1998, does not contain this social security for all. Okay, you have to remember this thing, very important. The other fourth thing is, the fourth thing which is mentioned in fundamental or core principles is elimination of discrimination in employment. Okay, this one you should remember. 1998 declaration, ILO fundamental or core principles established on 1998. Okay, right. While social security is a vital part of the ILO's mission, it is not listed as a fundamental principle. Okay, it is not a fundamental principle in this specific declaration. Okay, right. Very, very important. Which year they have asked this question? We'll see. 2016. Okay, latest one. Okay, right. Next question. As per the Trade Unions Act 1926, you have to go through all the laws, labor laws, industrial laws for upcoming UPSC, AO and APFC exam. Okay. As per the Trade Unions Act 1926, before independence, there was an act on trade unions. Okay. For the registration of a trade union, the minimum number of persons employed in an industry should be how many? 5, 7, 10 or 15. APFC 2015 question. Okay, please try to pause and attempt. We'll discuss. Okay, if you have attempted as per section 4 of the Trade Unions Act 1926, there can be 7 or more number of persons employed in an industry should be there for registration of a trade union. Okay, 7 is the answer. Okay, next. I have given you explanation also. Please go through it. Okay. The term social dialogue in the context of industrial relations refers to, next question, the term social dialogue. You should know what is social dialogue. Okay. I think fourth option is not visible. I'll try to give you that one also. A system of social security benefits provided by the government to workers. Okay. The term social dialogue, it is asked in APFC 2015 question, okay, paper, in the context of industrial relations, refers to the process of communication and consultation between trade unions and the government. Second option, all types of negotiation, consultation or simply exchange of information between representatives of governments, employers and workers on issues of common interest relating to economic and social policy. Whether it is correct or not, you should identify. The process of resolving industrial disputes through adjudication, okay, through court, through law, adjudication, meaning a system of social security benefits provided by the government to workers. Please pause and attempt. We'll discuss. Okay. What do you mean by social dialogue? Here answer is simple. All types of negotiation, consultation or simply exchange of information between representatives of government. See, it is a tripartite treaty, like you can remember as a tripartite treaty. Simple. Social dialogue is tripartite. 3 things it will come. So first one is government, then employers, and third one is workers. Okay, right. Government will act as a mediator. Okay, social dialogue between employers and workers on issues of common interest relating to economic and social policy. Okay, right. B is the answer. Right. Next one. I have given you explanation also. Please go through it. Next question. APFC 2023 recent one. Recent exam. Last conducted exam, APFC 2023. The concept of grievance in industrial social dialogue you have seen. Now it is grievance in industrial relations refers to what he is asking. First one is a major industrial dispute involving a large number of workers, okay, group of workers. A complaint or dissatisfaction arising from an individual employee's employment, okay. A demand for higher wages by a trade union, okay. A declaration of lockout by the employer. You have to identify. Please pause and attempt. We'll discuss. Okay. If you have attempted, we'll discuss. First, grievance meaning, you know, right? Grievance is an issue, any problem, any issue arises in industrial relations. What does it mean? It means a complaint. A grievance meaning other synonym is complaint or dissatisfaction arising from an individual employee's employment. Okay, individual employees employment. B would be the answer. Chalo, next. You can see the explanation I have given you. It is distinct from an industrial dispute. You have seen grievance, right? Now, industrial dispute. What do you mean by industrial dispute? Which is a broader conflict involving a group of workers. You have seen, right, in first option, group of workers. It is industrial dispute or a large collective issue. Okay, or a large collective issue. Right. Next question. Which of the following is an example of an unfair labor practice? Unfair labor practice. Unfair labor practice. On the part of an employer under the Industrial Disputes Act 1947. Unfair labor practice done by an employer who is giving employment under the Industrial Disputes Act. What does it mean? Asked in APFC 2023. Okay, first option, discharging or dismissing a workman by way of victimization. Okay, closing down a factory completely due to financial losses. Third one, transferring an employee from one department to another. Okay, from transferring of an employee. Whether it is correct or not, you should identify. Unfair labor practice. Promoting an employee based on merit. Okay, unfair labor practice. See, pause and attempt. If you have attempted, just identify this option. Just look at this option. Promoting an employee based on merit, it can't be considered as an unfair labor practice, right? Promotion means it is a good practice. You should eliminate this. By seeing this option, you should eliminate. If you don't know what is unfair labor practice, also by going through an options, also you can find out an real actual answer. Okay, discharging or dismissing a workman by way of, it can be considered. Closing down a factory due to financial losses. See, generally extreme statement. This is extreme statement. How can we say that unfair labor practice comes if any financial losses occurred to the company? If he is closing down, how can we consider unfair labor practice? He or she is in losses completely. He or she can't run the company. So how can we consider unfair labor practice? Okay, ultimately answer is discharging or dismissing a workman by way of victimization, any politicization, victimization through any discrimination, you can say. Okay, this is the answer. Sixth one, yeah. Next, the fifth schedule of the explanation. Fifth schedule of the Industrial Disputes Act lists several unfair labor practices. He can ask the question like, what are the several unfair practices mentioned? Which schedule of the Industrial Disputes Act mention unfair labor practices? Fifth schedule. Okay, right. I have given you an extra information to consider. Discharging a workman by way of victimization for union activities or other protected actions is explicitly listed as prohibited practice for an employer. Employer can't do these things because it is prohibited under the Industrial Disputes Act mentioned in fifth schedule. Chalo, next question. Which one of the following is not a method of settling industrial disputes as per the Industrial Disputes Act 1947? It is very, very, very important. 1947 Act. So all the provisions mentioned in this act should be thoroughly revised. Okay, thoroughly you have to make notes, short notes. Industrial Disputes Act 1947 is asking which one of the following is not a method of settling industrial disputes. Okay, right. First is adjudication, arbitration, conciliation. Okay, fourth one is collective bargaining. Please pause and attempt, we will discuss. See, they have asked in EO, Enforcement and Accounts Officer exam 2021. Okay, see, simply you can by going through options also you can identify this. A method of settling industrial disputes, any disputes, not only industrial dispute, any general disputes among people also be settled by adjudication, arbitration, conciliation, right? Compromise, right? Collective bargaining would not be the case. Okay, right? D would be the answer. Right? Simple. Chalo, next. Next. What is collective bargaining? While collective bargaining, while central to industrial relations, is a voluntary negotiation process. It comes from voluntarily, okay, between parties and is not a statutory method of dispute settlement defined by the Act. Act defined only through these methods: conciliation, arbitration, adjudication via labor courts, etc. Okay, right. Collective bargaining is not the case. Okay. Next question. The provision for a works committee for the purpose of promoting amity. The provision for a works committee for the purpose of promoting amity. 1 minute. The provision for a works committee for the purpose of promoting amity and good relations between the employer who is giving employment and workman who is working in his or her company is mentioned in which one of the following acts? Simple. Works committee is mentioned in which of the following acts is asking. Factories Act 1948, Industrial Disputes Act 1947, Trade Unions Act 1926, the Payment of Wages Act 1936. These four acts are very important for upcoming EPFO, APFC and AO exam. Okay. See, Works Committee is mentioned in Industrial Disputes Act. Okay, Industrial Disputes Act. Chalo, next. I have given you a little bit explanation also. Please go through it. Works Committee are established under the Industrial Disputes Act 1947 while we got the independence to serve as a bipartite body. Bipartite meaning dual. Okay, with representatives from both employers and workers. Okay, it is an simply you can say settlement body, issue resolve grievance settlement body to foster good relationship and resolve minor issues at the workplace level. Okay, workplace level. Right. Chalo, next question. Next question. Which of the following is the highest authority for the settlement of highest authority? There is a hierarchy, right, in settling disputes from local level to higher level. Which is the highest authority for settlement of industrial disputes under the Industrial Disputes Act 1947, EO 2017? Question. Labor Court, Board of Conciliation, National Tribunal, Industrial Tribunal. You can generally, if you pause and attempt, please, we'll discuss. You can generally identify this option C by seeing this National Tribunal. Okay, National Tribunal would be highest centralized, it would be at central level. You can remember by this word national. Okay, National Tribunal is the highest body in settling disputes, industrial disputes under the Industrial Disputes Act 1947. Chalo, next one. I've given you an explanation. Please go through it. What is the last question? Last one. Okay. What is the minimum number of women employees? Minimum number of women employees required to make it mandatory for an employer to provide a creche facility under the Factories Act 1948. What do you mean by creche facility? Creche facility is nothing but there should be an separate room for lactating mothers who are feeding their children okay, after delivery. Okay, right. If they are working in a company, there should be a creche facility mentioned under Factories Act 1948. Okay, during independence. How many employees, minimum number of employees required? Women employees is asking, he or she is asking. A, first one 10, second one 20, 30 and 50. You should answer. Okay, please pause and attempt. We'll discuss. See, in the Factories Act 1948 is asking minimum 30 members, 30 or more women employees is required to establish a creche facility under the Factories Act. Okay, in any company or industry. Okay, right. So 30 members, 30. As per section 48 of the Factories Act 1947 Industrial Disputes Act. Okay, 1947 Industrial Disputes Act. As per section 48 of the Factories Act 1948, a creche facility must be provided in any factory where 30 or more women workers are ordinarily employed. There should be 30 or more women employees to establish a creche facility. It doesn't mean if a company has 10 employees, he can't create a creche facility. He can establish. Okay, it is voluntary. But when it is in 30 members employee, 30 women employees company, it becomes mandatory under this Factories Act 1948 as per section 48. Okay, right. This is all about industrial relations. Thank you so much for watching till now. Thank you so much for visiting our YouTube channel. Please like, if you like this video, please like, share and subscribe. Signing off.